Welcome to what is possibly going to be the most fun panel, What Went Wrong. And before I introduce our speakers very briefly, I'll just say one of the things that's special about this collection of academics, I mean, yes, all of us complain about aspects of the law. It's one of the things we're trained to do, right? But each of these people has been instrumental in some aspect of reform. And I just want to suggest that although we're going to hear what went wrong from their perspectives, each of them has made a studied commitment, either in practice or on the page, to really envision a more positive set of possibilities for IP. With that being said, we have Mark Lumley, who's William H. Newcomb Professor of Law at Stanford Law School. And then we've got the University of California crew, starting with Mark McKenna, who's Vice Dean of Intellectual Life, Faculty of Intellectual Life at UCLA. Trevor Reed, newly Professor of Law at UC Irvine, and Pamela Samuelson, Richard M. Sherman, Distinguished Professor of Law and Professor of the School of Information. And with that, I will hand it off to Mark.
Yes, that's my mic. So.
Oh, that's your mic.
Literally hand it off.
Oh.
All right, whatever. I'm loud. It's not going to be a problem. All right. So this was, when Ed asked me to do this, I said, you've got me on the wrong panel. I have a paper, but the paper is really actually about what went right in the patent system. This was several months ago. And then Donald Trump happened, so it turns out to be a paper about what's going wrong with the patent system, at least in part. But let me start by saying what I'm basically going to tell you, right, which is after 40 years of pretty insane radical change to almost every aspect of the patent system, for the last almost a decade, things have settled down into a period of normalcy, at least until Trump. Right? So let me tell you, just let me give you a sense and background of like how things differed from 1980 until 2017. In 1980, we granted about 50,000 patents a year. Now we grant about 350,000 patents a year. Almost all the patents were in the mechanical arts. Now they are mostly in the computer or pharmaceutical and biotech arts. Most patents granted then were granted to single inventors. Now most inventors work in teams. Most patents granted then were granted to U.S. inventors. Now the majority of patents granted in the United States are to foreign inventors. You heard a little bit about Bayh-Dole earlier. We did not have really a concept of university patenting until 1980. Now it is a significant part of university life and invention. We used to grant patents to the first to invent. Now we grant patents to the first inventor to file. We used to grant patents for 17 years from issue. Now we grant them for 20 years from filing. We used to grant patents to people in kind of individual or small bundles. Now we have giant thickets and companies who own thousands and tens of thousands of patents. Related to that, we've seen a major growth in what we call continuation practice, the refiling and kind of multiplication from a single application into multiple issued patents. We had in 1980 about 750 lawsuits a year. Now we've got about 4,500 lawsuits a year. Most of the lawsuits in 1980 went before a judge. The jury trial was starting to become a thing in the 1970s, but it was still quite a small percentage. Now the vast majority of patent trials, are before juries. Most all of the lawsuits, when they were filed by product-producing companies against their competitors. Now a significant fraction, it has been as high as 80%, but it's still around 50% of the patent lawsuits filed in this country are filed by so-called patent trolls or non-practicing entities. Patents were invalidated in the 1970s at a rate of around 65%. Now the number is between 43 and 45%. Judge Alsup at lunch got the number pretty much right, I think, to say 40% of these patents are invalid, but the rest aren't. Patent appeals went to the regional circuit courts in 1980. Starting in 1982, they were consolidated in the federal circuit. In 1980, we had no concept of the patent office rethinking its decisions. And it wasn't until 1980 that we introduced the first concept, re-examination, then later inter partes re-examination, then post-grant review, and by 2017, IPR proceedings had become the way most patent validity disputes got resolved, and they had become the subject of most of the Federal Circuit appeals. We introduced the world of forum shopping, or at least district court forum shopping. We used to have some appellate court forum shopping in the 1980s, but almost the majority of lawsuits today are filed in districts that would have been unheard of in 1980. The Eastern District of Texas, the Western District of Texas, the District of Delaware. That's not where we litigated patent cases in 1980. Hatch-Waxman, the whole concept of pharmaceutical patent litigation against generics and ANDA cases did not exist. We introduced that concept in 1984, so the entire universe of pharmaceutical patent litigation has essentially been developed since 1984. We figure out what patent claims mean in what are so-called Markman hearings that we see in every patent case. Those hearings were created in the 1990s, cemented in a Supreme Court case called Markman in 1996. Before then, despite 200 years of patent history, we didn't know the answer to who is supposed to decide what a patent means, a judge or a jury. And then you've got the substantive law changes. In the 40 years between 1980 and the end of the 2010s, patentable subject matter is broadened to cover almost everything. Then it is narrowed again. We make major changes in the definition of prior art. We change to the first-to-file system. We eliminate the process of interferences where people are arguing about which one of us was the first to invent and therefore entitled to a patent. We change the law of obviousness in fundamental ways, narrowing it with the creation of the Federal Circuit and the teaching suggestion and motivation test, and then broadening it again in the KSR world. We weaken to the point of elimination the doctrine of utility in the Federal Circuit. We introduce a new doctrine of written description. We basically abolish genus claims in the life sciences by creating this new full scope enablement test. We effectively abolish fact-based litigation around infringement because all of the real disputes about infringement get resolved in the Markman hearing when we decide what the patent claim actually covers. We change the law of inducement. We introduce a concept of joint or divided infringement to deal with circumstances where more than one actor is collectively behaving. We strike down a large swath of our rules for inequitable conduct law, for penalties for lying to the patent office. The eBay case changes the rules for injunctive relief. So while we would have granted injunctions as a matter of course in 1980, we no longer do so. We apply the traditional principles of equity. We introduce, maybe not to the extent Judge Alsup would like, the idea of apportionment of damages, something we've done in the 19th century, but then kind of forgotten about for the intermediate procedure. We change our rules of willfulness and the advice of counsel defense, and we change our rules of venue. Right? So I list all of these things not because I want to talk about any one of them individually, right? But just to sort of give you a sense that if you've been litigating or teaching in this area for the last several decades, everything has been changing. Right? All the world of the patent system is fundamentally different, has been in flux for the last 40 years. Until about 2017. And starting in about 2017, a surprising thing happened, which is not much. We kind of settled in patent law into a period of normalcy. The Supreme Court decided 62 patent cases between 1982 and 2018, but it's only decided 3 patent cases since, and none of them in the last 3 terms, although it did recently take a patent case. So scholars are very excited about that. When it did decide patent cases, its recent decisions have had what I call an instinct for the capillary. It did not go for the central and important issues in recent cases. It's gone for the clarification of the scope of the doctrine of Asinore estoppel, which I'm personally a big fan of. I've written about Asinore estoppel, but it is not the central issue in patent law. It has decided 3 cases on Section 271F, the doctrine that covers what happens if you export components from the United States separately and then combine them outside the United States. As far as I can tell, there are only 3 cases in the recent history of patent law involving 271F, and they all went to the Supreme Court. It has decided the question of whether the Patent Office can recover its fees even if it loses when it is sued in a parallel proceeding under Section 141. And my personal favorite, whether the Post Office is a person that can bring an IPR proceeding against the Patent Office. None of these decisions are earth-shaking changes to patent law. Contrast that with the world of KSR and eBay and the patentable subject matter cases in the decades that preceded that really fundamentally do rewrite patent law. And when we do see substantive decisions in the last several years, those substantive Supreme Court decisions affirmed the existing law rather than changing the status quo. The Helsin case, the Amgen case, are 9-0 affirmances that the law is going to stay the way it is. Federal Circuit has settled down. En bancs in the Federal Circuit used to be twice the rate of any other circuit, and you saw a lot of acrimony in them. In recent years, there have only been 2 en bancs in the last 7 years. One on design patents, Mark McKenna and I litigated in one, and the other was a damages case that turned out to be a dud and nothing really happened. The dissent rate in the Federal Circuit dropped from the 2nd highest among all courts to lower than average. A lot of Federal Circuit cases are now non-precedential when they bother to write an opinion at all. Many of them are Rule 36 one-word affirmances. And then the law has just kind of turned out, even in surprising places, to be quite predictable. IPRs turned out to have pretty much exactly the same invalidity rate as court decisions at 1/10 of the cost, despite some false claims that you will hear to the contrary. Even patentable subject matter, recent scholarship shows, has turned out to be pretty predictable. All of this means that my patent law year in review paper has dropped from 100 pages several years ago to 50 pages. That's not nothing. They're still deciding cases, but they're not really fundamentally changing things. So I think in general this is a good story, right? It is a what went right. We've kind of come to a reasonable happy medium. If you're a patent litigator, you might not be so excited about it, right? Moving to IPRs means you get less money. If you're a patent professor, maybe you're less excited about it. There are less great things to write about. But in general, if you want kind of certainty and a reasonableness of the system, we've come to a reasonable place until Trump. Right now, all of this is in flux. The new PTO director is essentially dismantling large swaths of the PTO. He's made IPRs essentially impossible to get, but he's also ended up driving a bunch of examiners away by changing the sort of hiring rules, by increasing the quotas. He's refused to hire new career examiners. You cannot get a career job at the PTO right now as an examiner. We will not give you a promotion path. And he's on track to say we're going to replace examination with AI. I am skeptical how well that's going to work, but we'll be there. And that's part of a broader ecosystem of Trumpist chaos agents, right? Targeting scientific research, driving it overseas, placing 100% tariff on patented pharmaceuticals coming into the country because that will somehow magically reduce the price of drugs in the United States, taxing university patents, and my personal favorite, proposing that we tax patent owners on the value of their inventions when they file their patent applications. So some of this is chaos, some of this is maybe sort of lack of interest in it. So I don't know whether the period of normalcy we've entered is going to survive Donald Trump. We will find out. I will say one final thing, since we are standing here in a room and not out on a protest, and that is, fuck ICE.
So it's funny that Mark thought he was put on the wrong panel being put on what went wrong, because my first email I got first was from Tyler, and he asked me to be on the panel what went right, and I thought maybe he doesn't know me, and so, or doesn't know anything I've written. And then I got switched to what went wrong, and I was like, that makes a lot more sense. That's where I belong. And then I thought, how much time do I have? I have a lot to say about this. So, so this morning, I think Christine and Farley and Jeannie Frommer both pointed to some kind of significant changes. I'm going to focus here on two very big, significant conceptual and structural changes in trademark law. That's what I've been asked to focus on. That I think have really transformed what trademark law is, and with apologies to Judge Alsup, I think mostly for the worse. So the first is something that Mark Lonely and I have written a lot about, which is the basically unbounded expansion of the concept of source in trademark law. So as Christine was talking about, once upon a time, you can think about whatever period you want here, but sometime in the early 20th century, trademark law used to understand the idea of source to mean actual historical source of the product. So if you were asking, what a trademark indicated was it told you who made the thing that you were buying, literally who made it, what factory it came out of, who was behind that. In that world, infringement was very tightly limited to cases where consumers would believe that the defendant's products actually came from the plaintiff. Right? That was what I meant by passing off. So trademark rights were limited to directly competing goods, and only someone who was using the same or a very similar mark for directly competing goods for the purpose of tricking the consumers into buying one company's product, believing that they were the other. That was the scope of trademark rights. So that limitation was at that point very tightly connected to trademark law's theory of harm, which was about passing off. It was about sort of illegitimate diversion of trade. As the 20th century unfolded, courts, and almost everything I'm going to talk about today is about courts because they're the primary drivers in this story. Courts came to regard that definition as overly limited. So commerce is changing in the United States, and courts wanted to capture at least a couple of newer commercial practices within the scope of trademark law. So specifically, they wanted to capture the outsourcing of production and the expansion of product lines to adjacent areas by the same company. So courts wanted, for example, to allow Coca-Cola to license independent bottlers and still be able to say that they were the source of the Coca-Cola, even though technically that wasn't true, right? Somebody else was putting it in the bottles and selling. That required redefining source in terms of control over quality, which is how we all teach everything about trademark law now, rather than about actual historical source. So it was like making this sort of legal fiction that what it meant to be the source of something wasn't actually that you were the source, just that you exercised control over the products that were traveling under that mark. And then they also started to recognize that consumers might be confused about the same use of the same mark for adjacent products that weren't directly competing. So cases like the one that Christine mentioned, the Aunt Jemima case that involves pancake mix and syrup. Under kind of an old model, you would have thought those are not the same thing. No one buys pancake mix thinking that it's syrup. But courts started to say, well, the same company might have the same skills to make both of those things. They wanted to expand into that adjacent area. So those changes were, I think, totally understandable and widely supported even by those of us who've been really critical of trademark expansion. But what they did was they unmoored trademark law from its traditional focus on direct competition, and we've never replaced it with a real limit. So, as Mark and I have written, much of the blame here lies with the formulation that courts adopted to do this more expansive infringement. That formulation primarily goes by sponsorship or affiliation confusion. And that formulation, I think, as we've seen develop over the decades, is so open-ended that virtually any conceivable connection can be characterized in those terms, even though confusion about those different relationships might have very different effects on consumers or in competition more broadly. They still all travel under the same heading. And the net effect of that has been to make confusion in trademark law into, I think, really performance art, right? Where parties need to utter that word and to characterize their claim in confusion terms, but where everyone knows that's not really what the case is about, that really what they are is make weights for what really looks like naked assertion of rights and gross. So that's the first, I think, big change, is that the sort of the detachment of source from any real meaning. Okay, the second one, which these are connected, and obviously they feed each other, is the sort of structural collapse of what used to be a separate related body of unfair competition law into trademark law, and the resulting dramatic expansion of trademark subject matter. So once upon a time, again, only a much narrower range of things, of signs, were considered trademarks. Those came to be called technical trademarks, and those were things like words or what used to be called devices. You think of them maybe as logos now, that gave no information about the nature of the goods or their geographic origin, things we might now call arbitrary or fanciful, right? And also that were considered separate from and attached to the goods, right? So there's like a very sort of different, particular definition. So things that we now think of as possibly trademarks, like descriptive terms and geographic terms, those were categorically excluded. So were personal names, right? Things that were not separate from and attached to the goods were excluded because they failed the affixation requirement. So that would include all the stuff we now put in the category of trade dress, plus a whole bunch of other kinds of uses of marks that now sort of fall naturally. I'll just add here also that at that time, service marks were not a thing because you can't affix to something that's non-tangible, right? A service doesn't have a product you can attach it to, so there's no affixation. So in that world, use of the mark for technical trademarks on competing goods, that was called trademark infringement. And misuse of anything that didn't count as a trademark had to be addressed in this separate residual body of unfair competition law. That law was not about what somebody owned, because by definition, they were cases where the plaintiff did not own a trademark. Right? That was like what characterized them. So what the plaintiff in those cases had to show was that the defendant was accomplishing the same thing, that they were engaged in passing off, even though they didn't have a trademark, and that meant that those cases came with additional proof requirements and, generally speaking, much more limited remedies, right, where they were trying to basically address the problem of passing off, but without barring someone from using, say, the descriptive word or the geographic word. So that system collapsed. And for that, I think Sharon was talking about, we can mostly blame Erie. After Erie, unfair competition became understood as state law. It had previously been understood just as common law without any particular designation. And because courts started to believe that they weren't allowed to have common law unattached to any particular state, they started calling it state law. And that made practitioners and courts really nervous that the result would be 50 different versions of unfair competition law, where we once used to have a very uniform body of law. So I've written about this a little bit. That lack of uniformity was not actually happening, but everybody was anxious that it might, and so that forced them down a particular road, which is to say courts solved that problem, so it's solved in air quotes, that by recharacterizing things that used to be excluded from trademark status and calling those instead now unregistered trademarks, right? So now that was a huge change because those things previously were not just unregistered in the sense that someone hadn't chosen to register them. They were not registrable because they were not trademarks, right? You couldn't call them unregistered trademarks because they weren't trademarks. But they got recharacterized as unregistered trademarks, and then importantly, courts started interpreting Section 43A of the Lanham Act to give a cause of action for infringement of unregistered trademarks. That was not something Congress anticipated when they wrote the Lanham Act. It was not what they intended to happen. It was just a result of courts expanding to fix what they thought was going to be a disuniformity problem. But it was a huge change, right? Both in the sense that we lost the orientation of unfair competition as like a residual doctrine with more limited remedies, and also because it swept a bunch of subject matter into trademark law that was not previously there, subject matter for which we had no rules about how to evaluate the validity or ownership of those things because they were not previously ownable as trademarks. So we've now spent the last 40 or 50 years having to build basically from scratch that law about those designations, and I think in a way that has not been particularly successful. I'll just note here to finish that these two things I've identified, they really amplify each other, which is trademark subject matter has been redefined as anything that can possibly indicate source, just as we've expanded the idea of source beyond all recognition, right? So we've now sort of combined the two of those. And because those changes have for the most part been regarded as relatively incremental and not as radical as they were, a lot of courts have gone along acting like the assumptions that used to hold under the old system make natural sense in this new system, even though the structure and the scope of the law is like quite radically different from what it was at that time. So I'll stop there.
All right, good afternoon. It's wonderful to be here, and I feel very humble being in this little seat right here amongst wonderful people that I deeply admire and respect. I'm excited to be able to talk with you a little bit about one of the things that I think went wrong. How about Indigenous creative rights, right? Clearly not included in the 1976 Act, and I think I'll talk a little bit about that. Copyright Act's very and painfully silent on the status of Indigenous creative expression. And you might not think that that's that big of an issue, but it is for the citizens of the 500 and now 75 federally recognized tribal nations in the United States, whose copyright status is uncertain at best. And yet, in the lead up to the 1976 Act, Indigenous rights and contributions to American culture were widely acknowledged. And they were very much supported by Congress. Congress should have done a whole lot more, at least that's my argument. Well, when we think about the 1960s and 70s, Indigenous rights to creativity and culture and artistic and political expression were a big deal, right? They were kind of all the rage, from what I understand. I wasn't alive back then, but that's what I understand. We have the Red Power movement, the takeover of Alcatraz, not far from here. We have the Village People, right, donning a war bonnet, Buffy St. Marie, who apparently isn't Indigenous anymore. New Age religions and American Indian art was, of course, booming. Joy Harjo, a National Poet Laureate, Wayne Deloria Jr., authors Custer Died for Your Sins, calling out cultural appropriation, and of course many, many other contributions. And tribes themselves were becoming increasingly emboldened in the United States. In the 1970s, you have large-scale gaming operations starting up on tribal lands. Tribes start suing people along the East Coast to try and get their land back, or at least fair market for their rental value. And efforts were underway to enshrine Indigenous rights into international law. Now, amidst all of that, you have none other than Richard Nixon delivering what is perhaps the most important landmark address to Congress that would lead to a permanent change in the U.S.'s relationship to tribes, moving from colonizer to co-sovereign. And look where his starting point is. He says the story of the American Indian in America is something more than the record of white man's frequent aggression, broken agreements, intermittent remorse, and prolonged failure. It is also a record of endurance, survival, adaptation, and creativity in the face of overwhelming obstacles. It is a record of enormous contributions to this country, to its art and culture, to its strength and spirit, to its sense of history and its sense of purpose. So following Nixon's speech, Congress and the executive branch began reshaping federal law and policy to recognize tribal self-determination in all areas of life, including culture and creative expression. And it's in the early 1970s that we start to see, well, and here's kind of my roadmap that I'll talk about in a second here. But let me pull up my list of legislation for you. In the early 1970s, the Justice Department, for the first time, starts bringing charges against cultural appropriators. For example, Ben Diaz, a Scottsdale, Arizona art dealer, had stolen 22 handcrafted face masks, headdresses, and other cultural arts made by an Apache artist from a cave on the San Carlos Reservation, was displaying them in an art gallery and then attempting to sell them from the gallery. The U.S. attorneys working the case curiously brought charges under the Antiquities Act, of all things, even though the artworks were only 4 years old. So the trial court convicted Diaz, But the Ninth Circuit overturned the conviction, and it questioned how a person could be charged under the Antiquities Act for appropriating contemporary Native American art that was only 4 years old. The court reversed the conviction and held the act unconstitutionally vague. And of course, uproar of the act led Congress in 1979 to redefine antiquity to mean 100 years or older, but it did nothing to protect living artists from the likes of somebody like Diaz. And meanwhile, Congress had also been pressured by the Native American Rights Fund to repeal laws that actually imposed cultural discrimination against tribal creators. This is all done under the banner of religious freedom. Congress passed the American Indian Religious Freedom Act in 1978 that gives tribal members access to the locations and also the materials that were necessary for them to continue their cultural and creative traditions and also their performances. The only problem was that it didn't have a private right of action. Congress also clearly recognized the creative value of indigenous culture by passing the American Folklife Preservation Act only 10 months before the 1976 Act was passed. And of course, the Act aimed to preserve and promote American folklife, but listen to the different things that it covered: custom, belief, technical skill, language, literature, art, architecture, music, play, dance, drama, ritual, pageantry, and handicraft. So you can imagine, one of the first things that the American Folklife Center did was protect and preserve the 10,000 wax cylinders that were in the Library of Congress's collection documenting 100 years of Native American cultural expression. Finally, Congress passed the Indian Self-Determination Act in 1975. They gave tribes the ability to take over federal services and functions that were happening on tribal lands. So since 1975, tribes have taken over education, they've taken over healthcare, wildlife management, and many, many other programs, often doing it better than the feds, of course, and tailoring those programs to the policies of the tribe. So my question is, how is it possible that Congress did absolutely nothing for the tribes in the 1976 Act? Well, as it turns out, Congress has been doing nothing for tribes for a long time. The major advances in copyright law, as you can see, all coincide with major changes in indigenous rights in the U.S., many of them provided by Congress, but nothing ever happens. Congress never puts two and two together. And here's what the problem is. Let me kind of outline the things that, of course, scholars have been talking about for 40 years. I'm very grateful to Christine, who mentioned many of these in her own writing. Many of you have talked about these as well. Congress's failure to support indigenous creativity centers on a lot of different things. How about the fixation requirement for one of them in copyright law? Much indigenous cultural creativity has not been traditionally recorded or written down. That's particularly important now in the age of AI, to not write it down and let it be ingested, right? Does that mean that it shouldn't be protected against reproduction or distribution or public performance under federal law? Indigenous creativity often draws on traditional knowledge or traditional cultural expressions. Traditional knowledge and traditional cultural expressions are typically regulated by tribes and their laws. Thank you to my wonderful colleague Angela Riley at UCLA. But copyright ignores these tribal regulations. When a work contains traditional knowledge, copyright might just afford thin protection, or worse, might regulate it or relegate it to the public domain where anyone can use it without the tribe's oversight. Copyright makes several Eurocentric judgment calls that work should be protected for limited times, that it transfers to certain people upon death, that only certain facts should determine fair use, or that performances of certain places or certain causes are allowed, or that money is a sufficient remedy for bypassing free, prior, and informed consent. And finally, copyright makes an artificial divide between the intangible and the tangible, caring very little about how expression circulates in the material world. Indigenous peoples, by and large, care a lot about the dignity of our voices and our creations, where, how, or in what creation or in what form it's embodied, and who has the privilege of possessing it or handling it. American copyright, of course, affords very little control in these areas. My other beef with copyright is that it really is silent about tribal sovereignty. And I think that's a huge problem, especially in light of the United Nations Declaration on the Rights of Indigenous Peoples. As you know from Section 301A, all legal or equitable rights that are equivalent to any of the exclusive rights within the general scope of copyright are governed exclusively by the Federal Copyright Act. And exclusive of whom? Well, it says, no person is entitled to any such right under the common law or statutes of the state. I'm assuming the tribes can still regulate, right? They can keep developing their own copyright systems if they like. But it would have been nice had Congress actually formally recognized tribes' creative rights, and that they aren't extinguishable by the Copyright Act, and that things don't enter the public domain until tribes say they do. This is, of course, the minimum that federal law or international law would have required, but more importantly, creative works protected under tribal laws should have been protected against reproduction, adaptation, public distribution, public performance since the beginning. Tribal courts should have been recognized as the appropriate venues to hear copyright disputes, especially involving works within a tribe's jurisdiction. And finally, each tribal nation should have had the ability, under the Self-Determination Act, to take over the functions of the Copyright Office and control registration and deposit on their own tribal lands. And, of course, the realities are, in light of all of these struggles, here's my list, my laundry list. In light of these struggles, we've seen widespread cultural appropriation of indigenous culture, general devaluation of indigenous creativity and innovation, erasure of indigenous authorship. We know that there's extreme poverty on tribal lands. Estimates are that creativity and innovation on tribal lands account for 40 to 60% of the economy. Usually centers of creativity and innovation have large amounts of wealth. Yet on tribal lands, poverty rates are 3 times that of the American average. 40% of tribal members, tribal children, live in poverty. And of course, confusion over the source of accurate knowledge about tribal culture has been sacrificed. So these are my beefs with the copyright law. My hope is that all of us can work together to improve it on the next round of changes and transformations.
Thank you, Mark.
Giving you the precedent to go up to the
Yeah.
Oh yeah, well, the mic is flying. No, beside it, I couldn't get it back.
Okay. So, what's wrong with copyright? Statutory damages is the worst. Okay, that's just my. I am really sure of that. Okay, so, but there is. It's actually worth knowing something about its evolution. So, until the 1909 Act, the thing that was closest to being statutory damage was called a per sheet penalty, and it was a really weird thing because anybody, not just the copyright owner, could seek a per sheet penalty, and half of it went to the U.S. government. It's like really, really strange. And it wasn't used very often because mostly you wanted an injunction. If you were a copyright owner, you had to go to equity court in order to get an injunction. So there isn't that much use for it. But when the 1909 Act was being conceived, they decided that, hey, we should make a real thing that's statutory damages, and so they made it an alternative to actual damages or profits disgorgement, and that was especially good if it was either too difficult or too expensive to figure out what the damages or profits attributable to infringement really were. It was, but the courts had discretion about whether to do statutory damages or not, and that was a better system, actually, frankly, and it was a way to get some compensation or deterrence, but then the 1976 Act made some changes to it, and there's some good parts, right? So one is that Congress was persuaded that the per infringement basis of statutory damages under the 1909 Act was a bad one. It was too excessive. So it's per work instead of per infringement. And it had a tripartite structure, which made it seem like it was like more rational, right? So there's a range for ordinary infringement up to $150,000 per work now if the infringement is willful, but some discretion to lower the awards if they were innocent infringers or nonprofits basically thought they were doing fair use, and so it's compensatory. Now. Copyright industry has got some really nice little things here, which is, first of all, only statutory damages and attorney fees are only available if you register before the infringement happens, and the plaintiffs can ask for it, statutory damages until final judgment, and the judge doesn't have any choice. The judge, if they ask for statutory damages, you have to do it. And some courts say that statutory damages don't need to bear any relationship to actual damages, and that seems unfortunate too. Oops. So Congress failed to realize that they didn't think about secondary infringement, right? Such as what has become really important now, and they didn't think about what was going to happen when there was multiple infringements, multiple works, and the Cox v. Sony case is a good example of that. So that the jury were awarded almost $100,000 per infringed work. In that case, $1 billion, and the court basically said that it was, or the jury found it was willful, and so there's a huge thing. And I actually wrote an article some years ago that said, hey, there's it's arbitrary, capricious, and inconsistent, some grossly excessive remedies, and but I thought that actually is possible. To have some guidelines that would make some sense. So one of them was award the minimum where there's no actual damages or profits, or the plaintiff is unwilling to offer proof of actual damages. Approximate actual damages when there's plausible fair use or other non-infringement defense that's reasonable, and then maybe small multiples over a minimum or small multiples over actual damages when there's kind of reckless conduct, and maybe up to 10 times. Consider what would be necessary to deter this particular defendant, and I wanted them to try to start paying attention and develop a jurisprudence, and it hasn't happened, right? So big deal, right? So the Cox v. Sony case has two issues before the Supreme Court. The main issue is the standard for assessing contributory infringement. But the second issue the court took was whether this was a willful infringement. What's the standard for willful infringement? And unfortunately, the oral argument kind of just passed that one by. But the issues before the court, I think that they. It was actually a big deal that the Solicitor General came out and said that this wasn't willful because Cox was reasonable to continue to provide service, especially to accounts for their hospitals and barracks and things like that, so that cutting off the failure to terminate an account because there's some infringers there means that a lot of innocent people were going to be losing service, and that didn't make sense. So I'm actually hopeful that the Supreme Court will address this particular issue, what the standard for willfulness should be. Now, I'm really on the warpath now. If I thought statutory damages were bad before, oh God, they got worse. There's a very obscure part of Title 17 of the U.S. Code, and 5 rules outline tampering with copyright management information, which will induce, enable, facilitate, or conceal copyright infringement. The remedies for violation of this are pretty similar to the ones for copyright infringement, except that the statutory damage per violation is $2,500, that actually is, I think, really very high. So Congress must have really thought that tampering with CMI is really, really, really dangerous. But now it's being used in a lot of ordinary infringement cases, and the Doe v. GitHub case is now before the Ninth Circuit, and it in the Doe's complaint. There's no copyright infringement claim in that particular case. It's only 1202. Okay, and the complaint basically said we want $9 billion for violation of the CMI. So the claim is that when the GitHub stored those programs, they had CMI attached to them. And then they were used as training data, and now they're spitting out code that's functionally similar to the code that the Does actually wrote. And there's no CMI, so it must have been removed. And the distribution of the output without the CMI is basically a second violation of the CMI of 1202, the trial court dismissed the Doe's claims for lack of identicality. That is to say, if it was only substantially similar code, it's not identical code, and there's no CMI. Maybe it's not. Maybe there wasn't a removal, and so. I think that Congress really should revisit this whole thing, and there are some ways to interpret Section 1202 that don't give rise to the terrible outcomes in these cases. But I think that statutory damages here are really wreaking havoc on the law, and there's no discretion, so far as I can tell, for the courts to actually reduce them, and that's actually, I think, a really terrible thing. So a third of the 70-some cases involving generative AI infringement or violation have 1202 claims in them, and I'm on the work panel. Thank you.
Okay, we have, are we keeping on time to 3 or do we run it a little bit over? Okay, good. So we've got 18 minutes of Q&A, and I will kick it off with a question for the panel, and then think if you'd like to ask each other questions. We've been hearing today, I don't think I've ever been in an IP conference I've heard the word eerie so many times. I mean, I really think there's an interest and a concern in the tensions between state law and kind of federal and tribal and other, of course, international law. So my question broadly is, do we think that the drivers of change are the right ones, either right now or looking about what went wrong? And for context, we've heard today about bureaucratic changes in IP, kind of driving IP or reflective of IP from Saurabh. We heard from Sharon about common law changes among others, and Christine as well. Fred, we talked about the codification, so the tension between common law versus legislative change. We heard from Jeannie and Rob about private entities and their impact on the law. So I'm curious to hear from you what you think ought to be driving change and whether we're getting it right, whether that's part of what's gone wrong. So kicking it off with that question. Or start with what went wrong with that question.
Yeah. Right, I'll take a stab at starting. I mean, the reason I feel like it's such a hard question right now is it feels to me like so much of the superstructure of how we've understood the way that what law is now maybe just not applicable. But like one thing that seems really obvious is that Congress has just vacated the field. So, if I just focus on the trademark area, there was a time in history, Christine's done a lot of really good work on this, where there was a lot of thoughtfulness. Even if you think Congress got it wrong, there was a lot of thoughtfulness into what the rules ought to be and how that ought to interact with other kinds of areas of law. And now it's just Congress seems to do nothing, and if they did legislate in that area, they would just do whatever Intel told them to do. So there's that piece of it. Institutionally, I just think you can't really realistically expect Congress to be a productive force in it. And then, another thing that I think is probably seems to demonstrate to me very clearly over the last decade is we don't pick Supreme Court justices anymore because they're lawyers. We pick them because they have views on particular hot-button constitutional issues. And so we get cases that don't have any depth of understanding of the doctrine. And I think we have a bunch of examples of that. So it's hard to see there being drivers other than lower courts. But that has then the perverse effect of being who brings the cases and, what are their interests?
I think that's all great. Let me just add to it a couple of other things, right? One is, it's not just that we're picking Supreme Court justices rather than, as we should, on the basis of their knowledge of intellectual property law, but on some sort of political thing. We have, in the last several decades, collectively decided in the court system to abandon the concepts of common law and equity in favor of here's what I think the statutory term means because I looked it up in the dictionary. I think that is a disaster as a general means of statutory interpretation, but it is a particular disaster as applied to an intellectual property regime that was built entirely under the assumption that we had a common law development framework, right? Many of our legal doctrines are not even in the statute, right? They've been around for hundreds of years, but we sort of took for granted that the courts were going to develop these. And then a Supreme Court or an appellate court that sort of comes to them for the first time or for the first time in decades looks at it and says, well, gosh, the statute doesn't say there's a doctrine of equivalence, right? Maybe there shouldn't be one, right? And so what Mark talked about, what we heard about this morning, right, about the whole concept of the sort of common law parallel development of trademark law, I think fits in that category. So it's not just the Supreme Court aren't kind of necessarily focused on the law, right? We have systematically, I think, moved away from the tools that we have used for centuries to develop intellectual property law. So that leaves us with the executive branch. Even leaving aside the sort of chaos and disaster that is Donald Trump, right? One of the challenges about sort of handing this to the executive branch is you're not going to get sort of long-term consistent development. You're going to get kind of swings in policy. Maybe one of the reasons, sorry to go back to sort of the start of your question, that you're hearing so much about Erie and what will states do, what will tribes do, what will other things do is we're looking around at our traditional sources of federal law and finding them all working.
Technology is a big driver, at least in the copyright field. We just think you're resilient as a copyright lawyer and then get smacked upside the head with generative AI and billions of dollars that are at stake there. And, every other disruptive technology for copyright has just pissed off one industry sector. Right, so it was like when I was photocopying, it was journals, right? When it was tape recording machines or DAT machines, it was just the recording industry. When it was Betamax machines, videotape recorders, it was just motion picture industry. And now everybody's mad, and so that's. The Copyright Office got more than 10,000 comments when they put out their call for answering questions about generative AI. That's not a good way to do things either. And so we don't have any institutions right now that really can help us. And the dismantling of the federal science community is not a positive development there because, you know, there are people who are technology who aren't Elon Musk and who are actually wanting the economy to grow and fairness to be done, and also understand what the technology is. And what you have now is like everybody just freaking out. And, you know, I mean, one of the things that I say sometimes when I'm giving talks about generative AI is that copyright right now is the only law on the books that could bring the whole thing down and destroy it, right? Because a lot of the complaints in these generative AI cases ask for a destruction of the models, and I don't think that's going to happen. But one of the things you can do is you can have the copyright owner, who's the plaintiff, can actually impound. They can destroy, right, or they can get a destruction order, but they can also otherwise dispose of. And so some of those people could end up having control over the models, not the developers. Now, again, I don't think that's going to happen, but technology is just a real tumble right now for us, and a very destabilizing part of what's going on. What are we in, Trevor?
Yeah, I guess I would agree with what's been said. I think those are kind of the challenges with getting kind of public support behind a big change. But I think.
Get closer to your mic. I have a
sorry.
question.
All right, I think probably one of the things that a lot of people are not enthusiastic about are kind of the tired philosophical underpinnings of what we're talking about here. I think people are losing faith in the economic rationales to IP. I think they're seeing the power players taking advantage of IP, and the folks that are powerless don't. Social justice, I think, is becoming a bigger rationale for IP these days, and I think people want to see more of that. Unfortunately, we keep spitting out economic rationales for these types of things, and it's not going anywhere. So I think what needs to be driving the conversation is more about what people are actually feeling and experiencing on the ground. You know, we see a lot of, 2020, right? The retirement of racist brand names, mascots, things like that. Did that follow the trademark rules? Did that follow, the typical rationales? No. We wanted justice. We wanted things to change. And so, pressure was put on different corporations to change the trademarks, right? And I think that's where we get the enthusiasm. That probably should be what's driving a lot more of the conversation.
All right, let me turn it over to the audience. I'm going to bring it to Professor Lee.
Mark McKenna, I have a question for you that I think you'll like. What went wrong in Daystar?
Yeah.
Because
We definitely don't have enough time for that.
Let's
take a break, right?
I mean, was that a Supreme Court case? Because nothing happened with it, right?
Yeah.
So then what went wrong with it? Or was it a law review article in which the author noticed some of the things that you noticed, which is that there was an unfair competition kind of claim jammed into trademark law, and that the concept of source had no bounds and would create so much trouble unless it was given some kind of constrained meaning. And the author of that law review article proposed a constrained meaning. Did they get it right? Or what can we do with it? Seems like something went wrong.
Yeah, I mean, there's no bigger fan of Daystar in the world than me. So, but you're right. It's been basically, I have a couple times in conferences predicted that it would be like the next big thing, and then it's never been true, which tells you a lot about my predictions. But I think the answer is, one is the case is hard. Like every time I teach it, like you have to really dig in to understand what the court is saying. That's, I think, related to what I was saying about in the Supreme Court is like whatever else you thought, the guy was smart and he was able to like understand what the arguments were. And I just think the engagement with that level now is just much more superficial. But I think also just a lot of courts just don't like what it produces as outcomes, and so they just avoid it. They try to find ways around it. And so, that's that's not really a legal answer, but I think it is a practical description of what's happened with it. And I think the consequence of it will be lots more people using some form of trademark law as a backdoor form of protection of copyright, especially if and when anything actually goes in the public domain.
Next question to Dwayne Valls. Did I say your name right?
Yes. All right. Professor Samuelson made the point that these days with generative AI, everyone's pissed off. It's drawing in a lot of incumbent industries who are concerned. I think if we go a little before that and just look at the advent of the internet, that brought all of these different areas of IP together on some of the same subject matter of engagement and how people were really transacting, interacting on the internet. And the internet is a regime of plenty, right? There's a lot of surface area for trademark disputes, a lot of surface area for copyright disputes, and we found some ways of managing that. But it still strikes me that some of the points about damages being overwrought, some of the rights being overwrought relative to the types of claims or infringements that people have, could be addressed in part by more rational transactional systems. So if, we have a disposition against compulsory licensing in many regimes here in the US, but isn't there a more rational approach saying these rights are legitimate, but we need a better framework given the realities of how the technology works and how people are actually engaging in it in a way that's going to be efficient and not lead to windfalls in one case, or you're just out of luck in other cases?
Pam probably has something to say about this too, but let me take a start. So, I think it is attractive in concept in some ways, and whether it's attractive in practice, I think is more challenging, right? So, I'll note two things, right? One is, I think the experience of the internet mirrored the experience of all of the sort of prior technologies before it that worked in the media space, right? Which is immediately the existing incumbents freaked out and said, this is going to kill our business, right? We're never going to be around, right? You can go back to the phonograph record player, right? Which was going to destroy the market for sheet music, and people wouldn't sing at home, and music would never be the same. And, these are disruptions that happen, right? In every case, including the internet, it has turned out, right, that the technology, once you figure out a way to make it work for you, is better for the creation of content than what we had before. But when we're in that period where we're disrupting the existing business model and people panic, a lot of the reaction is to say, well, either shut it down, right, which we tried to do for the internet for several years, right, or you need to pay us, right, to sort of sustain the existing business model. I think there ought to be and will ultimately be a way to get paid for creative content on AI, just like there was and ultimately for the internet. But I wouldn't have wanted us to say, the thing we've got to do is make sure that the record labels draw the same percentage of the content that they did when they were actually providing services in response to that. And I think we're right now in the AI space of, oh my God, panic! It's going to destroy everything. I can't promise you that it won't this time destroy everything. I can tell you that the last 12 times, and I did a 150-year history of this in a paper, and the last 12 times people said, oh my God, it's going to destroy everything in our content industry, not only turned out to be wrong, but they turned out to be spectacularly wrong. And so I would like us to try to figure out a way for people to get compensated that is forward-looking based on what people are contributing, and not how do we preserve the existing industries that happen to have gotten money from this.
So I just wrote a paper recently about collective licensing and whether that's a reasonable compromise. Generative AI companies would be able to do their stuff, and there's some compensation that would go. And it's a really attractive idea. It's just I don't think it's possible, and at least not possible really realistically in the United States. And now that isn't to say that there aren't licensing agreements that are happening. There are lots of licensing agreements that are happening, and I have no quarrel with that. But the idea that every author of every blog and every author of every picture that's on the internet that has been used as training data is going to get compensation. Just try to think about everything that can be digitized. Is a different work and has different authors, and we don't know who they are. The information about ownership that's on the internet is actually a little bit, shall I say, incomplete, and so there are just lots of hurdles to that to get to ordinary individual authors, and so while I think the Europeans are very enthusiastic about collective licensing, another thing that they have which we don't is a body of collecting societies that basically know how to do this kind of stuff. And the only industry for which collecting societies really work is in the music business. And outside of that, there just aren't the kind of collectives that would make it possible for us to do it. And a lot of the ideas, even in Europe, is give the collecting society a whole bunch of money, and then they'll support creative activities. But it'll be more like grants, it's not like everybody's going to get a $50 check from the collecting society for the minute contribution that they made to the training data. So again, I wanted to give this a fair shot, but I just don't see it being feasible.
Okay, I'm going to make a couple quick comments to try to tie things up, and then I'll release you to caffeine and whatever else is outside. One point I wanted to surface is to echo what Trevor Reed said about the perspective that we take in intellectual property in general, and that the dominant perspective has to be economic. And when we're talking even about compulsory licensing, we're really talking about a liability rule instead of a property rule, and the idea being that we can't actually stop you from doing something. We're just going to charge you for it after the fact. And I think it's worth our thinking about the extent to which this economically focused model in the United States really harmonizes with other countries. We heard from Rebecca Tuchman earlier about how 512 has been adopted in certain respects, as a model, or at least has been followed. And I think it's worth thinking about what we're doing in this country and what other countries are doing, and what even within this country we're doing vis-a-vis sovereignty and tribes. And I'm thinking that it's worthwhile to be thinking about social justice as well, because in our next panel we're going to be thinking about what's next. And that's not to say that everyone on that panel will be thinking from this perspective, but I think in this institution here at Santa Clara, where we do think a great deal about the mission and about serving the larger public, it's worth thinking about the role of law and how we both practice and how we even talk and think about it. So please join me in thanking the panelists, and we will come back.